Hi everyone, good evening. We can go live now. So Shampadi, please begin.
Namaskar. Good evening to everyone. I welcome you on behalf of the organizers, the Symposium on Global Reproductive Politics, Reproductive Justice, and Limitation of Law, Agenda, and Structure. We all know that sexual and reproductive health rights is about taking full autonomy and control for all people. Global legislative and advocacy landscape is obviously dynamic and complex. It's not static. And there have been many kinds of advocacy going on throughout the world. There have been many success and many setbacks. This discussion today is important discourse. When we are again at crossroads, we know what's happening at the US Supreme Court. Discussion is going on about abortion rights, and in many countries, there are laws getting changed. There are different kind of initiatives taken where access to reproductive rights has been denied to people who are marginalized at different levels. And one thing is very important to remember that who decides on behalf of us about reproductive rights of our lives. And that is something we need to understand. For today's symposium, we would like to bring into a rights-based framework. Today's symposium is getting translated. There is a sign language interpreter. It is getting translated to other languages also. So there is one request to all the speakers to speak very slowly. You cannot speak very fast if you want the translations to happen simultaneously. With this, I'd like to hand over to my Shai, who will be introducing all the panelists. And once again, I welcome you all. We look forward to an evening of very important and interesting discourse today.
Thank you, Shampa. And as Shampa has said, today's symposium is basically looking at furthering the discourse on the need for a rights-based framework for sexual and reproductive health and rights justice. The Law and Marginalization Clinic at the Center for Justice, Law and Society, Jindal Global Law School, Shruti Disability Rights Center, Trans Care India, Rising Flame, the Asian Pacific Resource and Research Center for Women, Center for Reproductive Rights, Trans Women Collective, and Common Health India. These are all the organizing members. They are all collaborating in order to organize this symposium on global reproductive politics, reproductive justice, and limitations of law. We welcome you all. And the symposium today is going to have two panels. The first panel is going to focus on decriminalizing abortion and towards a rights-based approach. And the second panel is going to focus on reproductive justice and a discourse for centering access. The first panel today is going to be moderated by Andrea Parra. We have with us Andrea Parra, and Andrea Parra is a queer Colombian attorney, a feminist legal activist, experiential training and a trainer and a translator. She is an independent consultant with various human rights organizations and grassroots groups who are focusing on trans rights, sexual and reproductive rights, and disability justice. She is the co-coordinator of the Latin American Network on Article 12, the director of Talaristas por la Justicia, and the co-director of ALCE. Welcome to Andrea Parra. Now, the second panel, this is going to be on reproductive justice, a discourse on centering access. And this is going to be moderated by Vikram. VQ is an independent researcher. They live and love in Delhi, India. So that's the introduction to the moderators, and we look forward to a great session today. And over to Andrea.
Thank you so much. Thank you to all the organizers for the invitation to moderate this panel. I'm really excited to see old colleagues and meet new ones. And just a reminder for everybody who's participating, we have interpretation in various languages. You may click the globe at the bottom of your bar that says interpretation and choose the language of your preference. And just so everybody know, we have 74 people right now connected into this call without counting the panelists. And it's a pleasure for me to be moderating this first panel with such amazing people. And I'm going to introduce two of you who they are before I pass them the word. So Alicia Yamen, who I am really happy to see here, is an old colleague, and she's currently a lecturer on law at the Senior Fellow on Global Health and Rights at the Petrie Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. She's an adjunct senior lecturer on health policy and management at the Harvard T.H. Chan School of Public Health and senior advisor on human rights and health policy at the Global Health Justice Organization Partners in Health. She has lived and worked in Latin America and East Africa for half of her professional life, working with and through local advocacy organizations. And if you haven't checked some of her publications, please do, because they're very enlightening. Next, I'd like to introduce Clara Rita Padilla from the Philippines. She's an attorney and the founder and executive director of End Gender Rights. She's the spokesperson for the Philippine Safe Abortion Advocacy Network, PINSAN. She has been practicing law for over 28 years and is known in the Philippines and internationally, working in the fields of gender and diverse SOGI. So she drafted the proposed bill to decriminalize abortion for PINSAN and has won several Supreme Court en banc cases, including Ang Latlat versus Comelec, the constitutionality of the RH law through an intervention, the Pioneer Textile Corporation versus NLRC, and Lourdes de Jesus. It's a pleasure to meet you, Clara Rita. We haven't shared the spaces before. Agnieszka, who I also know from a while ago, is a sociologist, researcher, an activist, as well as a member of Estrefa Buenos Esmilo, an association advocating for the rights of women with disabilities. As an academic, she is affiliated at the Jagiellonian University in Krakow in Poland, where she conducts research on disability, motherhood care, and reproductive autonomy and experiences of motherhood of women with disabilities in Poland. Her main interests are located in the fields of gender, disability, and diversity studies, as well as qualitative and participatory methodology. And finally, I would like to introduce you to Phyllis Mbeke Ndolo from Kenya. Phyllis is the Executive Director of Women's Spaces Africa, a feminist disability-led organization working on access to information and services on SRHR. She has been working with the grassroots movement on advocacy for sexual reproductive health and rights for the past 14 years, and is a champion of the inclusion of girls and women with disabilities in mainstream development, taking cognizance of their double marginalization that arises out of gender and disability stereotypes. So as you can see, it's a very powerful panel of speakers from different regions of the world. And we would like to invite the panelists to offer their views on one or more of the following themes and draw from their own jurisdictions in doing the same. The first area of consideration, and I think there is again an issue with interpretation over it. I mean, let's see if we can resolve some of the tech issues. One is the disproportionate use of criminal law to regulate reproductive decisions over the world. And this is a particular moment, as we all heard about the leak to revoke Roe v. Wade in the US, at the same time that in Latin America and other countries, abortion laws are advancing, and still persecution of abortion advocates continues to occur through criminal law. The second topic is the intersection between law and religion, and how this continues to filter through our own context. And the third area is the role of law and social movement in advocating for decriminalization. And the fourth one is strategies advocacy movements employ while negotiating with the state for decriminalization of abortion. So I don't know how we're going to cover all of that in the time we have, but I trust the wisdom of our panelists to share some of the amazing work you've been doing. So I'm going to pass the word first to Ali, and let's go.
Well, thank you so much, Andrea. It's really a pleasure to be sharing this space with you, and also with so many new and colleagues whom I greatly respect their work across the world with a very intersectional lens. As Andrea suggested, there's a lot to cover, and these topics bleed into each other. So in my 6 minutes, I'm going to make a few remarks about the leaked text of the opinion from the US Supreme Court and compare it to what is going on in Latin America. I will say from the outset that I really care about reproductive rights in the sense of reproductive justice and access, effective enjoyment of access to abortion rights. And I also think that the title of this panel, and that a rights-based framework, some of my remarks are going to go to suggest that there's not a single monolithic rights-based framework, but that rights can be used to frame these cases in a variety of different ways. So as pretty much everyone, I imagine, knows, there was an opinion leaked that is confirmed as a draft opinion by Justice Alito, which it suggests that the US Supreme Court is poised to overturn Roe v. Wade and Planned Parenthood versus Casey, which extended and modified, it took the viability line and it introduced an undue burden test in terms of when states could regulate access to abortion before viability. I do want to stress a few things about that leak and about Roe v. Wade and the abortion law in the United States in general. One is what I alluded to initially, which is that there is an enormous difference in this country, and there has been for decades, between legal entitlements and actual effective access to abortion rights. And that has to do with the way our health system is set up, the way the legal right was constructed very quickly after Roe, the use of federal funds to underwrite poor women's access to abortion was cut off. So this has been a long battle, but that's something to keep in mind. The second thing to keep in mind is that this is a major change, a tectonic change in the jurisprudence of the court. This is a 50-year-old precedent, just what we would call a super precedent. There really is no evidence to suggest that changing circumstances or need have impelled this decision, but rather that it is a change of personnel on the court, and that abortion rights may not be the only domain targeted, right, in sexual and reproductive health or more broadly. Justice Alito's opinion emphasizes that abortion was not an enumerated right. He talks in the leaked draft, and again, we don't know what the final opinion will say, but there's a suggestion that abortion wasn't on the founders' minds when they drafted the Constitution. And of course, when the United States became a republic, as many people have already pointed out, women were actually not treated as full legal citizens, and there's no reason to expect that abortion or any sexual and reproductive right would be an enumerated right in the Constitution. So I want to turn and compare that restriction, which the way this draft opinion is written could extend beyond overturning Roe v. Wade and abortion rights to going after things like contraception. There's also obviously a wave of anti-trans legislation and measures to restrict access to services for LGBTQ, especially LGBTQ youth in this country. There are also efforts to restrict voting access. So it's reproductive justice. It's a closing of the who belongs in this political society and demos, really regressing decades. So the second thing I want to compare that to is the progress that Andrea alluded to in Latin America. In the span of a few short years, just in December of 2020, Argentina legalized abortion through 14 weeks. We saw Mexico, the Mexican Supreme Court decriminalize abortion with no time limits. And we just in February of this year saw Colombia decriminalize abortion to 24 weeks, and thereafter under certain conditions that had already been recognized under law. So I want to point out that there are some differences in the law, in politics, and in activist and social mobilization that are worth considering between the United States and what's going on in Latin America. So in terms of the law, the genealogy of abortion rights is quite different. 2 minutes left. Okay, so decriminalization comes from more of a balancing proposition that the obligation to carry a fetus to term is a sui generis obligation that cannot be imposed, forced upon a woman. But there's also been a lot of framing of equality, of connections to democracy movements, of connections to democracy and a secular state, which is an important part of the feminist claim in Latin America. And the right to health. So these are countries that generally incorporate international human rights law into their domestic constitutional law. They have more robust enumerations of economic and social rights in their constitutions in any case. So the kind of nexus, the normative nexus that they had to draw on is quite different. The second thing is politics in at least Mexico and Argentina, and I wouldn't say this exactly about Colombia, but for example, in Argentina, it's a very polarized political situation, but the parties are divided about abortion. It's not like in the US where Democrats are generally held to the pro-choice line and Republicans are uniformly against abortion access. And the third, which I will come back to because I only have 30 seconds left, is activism. I think the role of linked networks across the region, the different domains, not just litigation, but real social mobilization, working with providers, doing popular outreach and education about women's rights under the exceptions to criminalization. Cultural symbols and uses of things like this green kerchief, which women would wear on their backpacks, are usually around your wrist or something. This one's from Argentina, but that is symbolizing the green wave, have all been extremely important. So I will stop there and I'm happy to answer questions in the second round.
Just get to scratch the surface. Thank you, Ali. I'm going to pass the word next to Clara Rita Padilla.
Okay, thank you, Andrea. Thank you, everyone. I'll go straight, and I'm going to discuss the arguments that we use in the Philippines. And in relation to law and reproductive decisions, a woman or pregnant person's decision to terminate a pregnancy is a personal one. There should be no government intrusion on basic rights to privacy, such as contraceptive use, who to have relations with, abortion, among others. There should be no criminal penalty for any person who wants to undergo an abortion. This is clear disregard of women's personal decision-making. It's a clear manifestation of control over women's bodies and the long-standing subordination and disrespect of women's rights. Women must have the freedom to decide their quality of life, their destiny, without government control. Our restrictive law on abortion in the Philippines is a law adapted from the colonial Old Spanish Penal Code of 1870, where Spanish Catholic friars and marginalization of women was in its height. This was a time when women were not allowed to vote, work with pay, or even go to college. The Philippines is a predominantly Catholic country, and as we know, many religions have remained patriarchal and have relegated women in the background. I've always believed that religion must be separate from law and governance. Otherwise, the rights of women and LGBTIQ people will be trampled on. It's important to have a law decriminalizing abortion because it will make abortion safe, legal, and accessible for all. Women will be free to terminate their pregnancies regardless of reason. With a law decriminalizing abortion, there will be clear recognition of a person's decision to terminate a pregnancy. People will follow the law, and the stigma related to abortion will be eliminated. A law to decriminalize abortion will only be passed with a strong social movement. We need people to make it a buzzword during elections, in schools, at the dinner table, with the taxi driver, salons, among others. When I drafted a bill to decriminalize abortion for the Philippine Safe Abortion Advocacy Network, we conducted discussions with various sectors, and we launched the draft bill in 2020. When I posted my picture on Facebook with the draft bill, it went viral with about 12,000 supporters, but I was also harassed by trolls. What I did then was I befriended my supporters on FB, and our network has been working with them in online discussions, many of them very young women, including 18, 19-year-old young girls. We have an online sign-on petition with almost 30,000 signatories as of now. We made decriminalization of abortion an election issue, where presidential candidates were asked about their stand on abortion. There was one party that advocated for decriminalization of abortion, with one Senate candidate who made a strong call to decriminalize abortion, and many feminists and young people voted for him. So I would say that we are gaining ground. And when this particular senatorial candidate expressly advocated to decriminalize abortion, and there were social media cards that came out in the newspaper, we were seeing about 100,000 supporters from people we did not know. And this is a pleasant surprise for all of us. And this would show that in the last 3 years, we have indeed made excellent strides. And so thank you. That would be all for this round.
Andrea, apologies, you're on mute.
Thank you, Natasha. Thank you, Clarita. I'm going to pass the word now to Agnieszka Kroll from Poland.
Thanks a lot, Andrea. So I'm based in Poland, and I will be tackling this situation, especially when it comes to the role of the social movements and the fight for abortion rights. So our situation in Poland, so Eastern Europe, has become infamous for restricting abortion rights that happened by the decision of the politicized Constitutional Tribunal in 2020. However, the first efforts to introduce a near total abortion ban in Poland started in 2016. And this was also the year where the first massive protests for the abortion rights took to the streets. And to understand well the situation in Poland, I feel that I need to give at least 4 contextual information to let us understand it better. So first, when we look at the region, Poland is the country with the most restriction access to abortion among the European Union countries, but also the post-socialist region. Secondly, historically, if we look at the Poland's history, we see that it had a much more liberal abortion law. And during the democratic transition, so in early 90s, the abortion rights were restricted as a consequence, and here I want to highlight it, as a consequence of the agreement between the political elites and the Catholic Church. In practice, what it means that in the same country, a big part of people living there has an experience in living in a country where access to abortion is widespread. The third thing I want to point to is that for more than a decade now, Poland was going through a very intensive anti-gender campaign that was targeting both feminist issues, but also LGBTQ rights that laid the ground for this restriction of the abortion. And fourth point that I want to make is that this decision by the Constitutional Tribunal happened in the horizon of having a decline in democracy, specifically the rule of law crisis in Poland that led to the Conservative Party having de facto control over the legislative bodies in Poland. So clearly we can see the link between abortion laws, shrinking civil space, anti-gender movements, and religious hegemony. Prior to the restriction of the abortion law, the legal abortion was very limited, with amounting to approximately 1,000 abortions for a country that counts approximately 40 million people. And almost all cases were happening under the premise of quote unquote severe and unrevertible fetal abnormality. And this exact premise was made unlawful in 2020, which made it very, very complex to navigate for the right to abortion from anti-ableist perspective. And this is something I want to speak more later on about also. And if we speak about the role of the social movement, I want to highlight that social movements play really a key role in defending abortion rights, successfully stopping the attempt to introduce near total abortion ban in 2016. And it was unprecedented mobilization that for good have changed the feminist movement landscape in Poland, as during the protest, a very important and unique space for variety of reproductive experiences that were very much taboo was created. And I think we cannot underestimate this aspect of protest that created this possibility of expression and articulation of reproductive injustice experiences within this patriarchal context, because they really do touch on the core aspect of the rejection of the gendered control over sexuality and the body. And now what's happening in Poland is we really observe a very strong support network driven by organizations like, for example, Abortion Dream Team, that provides access to pharmacological abortion and abortion abroad. As well, we see like new legislations being proposed. To be symbolic, we see numbers to the abortion helplines being sprayed on the walls of the churches. And also a very nuanced analysis about abortion rights, including its class dimension, rural-urban divide, gender and sexual diversity also is very much present. But also, and this is my last point, in recent months, we have also witnessed the very harmful consequences of the law with deaths of women who did not obtain abortion on time. This was the case, for example, of Izabela from Pszczyna, who died because the doctors waited for the fetus to die to the last moment. And last month, we also have faced the first trial of Justyna, who is an activist accused of supporting abortion. She's facing 3 years in prisons for helping someone access abortion pill. While Polish law does not penalize the person who has abortion, it criminalizes the person who does support. And let me stop here and thank you for this space to tackle these issues.
Thank you, Agnieszka. I'm going to pass the word to Phyllis and ask if you can please mind the pace of your speech so that interpreters can interpret correctly. Thank you.
Okay, thank you. So, yeah, I'm discussing about the some of the ways or the progressive ways that the civil society we are able to look at and maximize and see how we can push for decriminalization of policies and laws that have continuously made us lag behind. First of all, Kenya still inherits the colonial laws where the Penal Code says that anyone providing an abortion service to a girl will be penalized for up to 14 years. If I'm a girl or a woman and I've sought for an abortion service, I'm able or I'm liable for punishment by law up to 7 years, or anyone who's supporting a girl or even selling drugs to a girl or a woman to procure abortion is liable to jail for at least 3 years. And in 2010, the Kenya constitution progressed, and we had a new article, Article 46, where Article 26, Clause 4, I correct that, Article 26, Clause 4, where now abortion was introduced to the constitution according to maybe restrictive conditions, may it be the health of the mother is in danger, or after a health trained professional has said that you can procure abortion. However, with this progression, we are still facing a lot of challenges. Patriarchy, religion, values and culture continue to hold us back. What have been some of our ways in Kenya that we have maximized and utilized to push for decriminalization of these laws? It is evident we are having girls and women dying. So we have had petitions taking the government to court. For example, to reinstate standard and guidelines where we say that it is the right of the girl, of the woman to get the highest attainable reproductive health service. When she has procured an abortion, it is a right to get service and not for her to die. We have seen the CSO taking the government to court so that they are able to reinstate these policies and guidelines where we are not seeing the health providers not giving a service because they are afraid they are going to be harassed by the state. The other time that we've maximized, and we also recommend can be maximized, is when the healthcare providers are being harassed by the state. We have seen police coming to seek for bribes and faulting that the healthcare providers are giving abortion services simply because they know that under the penal code, if you accuse the health provider that they are giving or helping a girl procure an abortion, then they are liable for jail. So these are some of the ironies, taking petitions to court that one, girls and women are dying. And it is evident, for example, we had the JMM case. If you go online, you're able to see it, where a girl died due to procuring unsafe abortion. And when assessing services, the post-abortion services, she was not able to get the highest attainable levels of services because the healthcare providers did not have the standard and guidelines. The other times that as Kenya we have used and maximized how we can decriminalize and push for changes is when we have policymakers that are progressive and are able to identify with the issues on the ground. So these are some of the avenues that we have really tried as a country to hold accountable the state and really try to push for petitions and really try to push on how can we maximize on the clause and the gap that the constitution leaves for us. And saying that, Kenya is a driver to the East African region policies and the community on reproductive health. So this I'm seeing this quite being embraced by our neighboring countries, that we are able to take the state to court to push for better policies. The other thing is the intersection of disability and abortion. It is a very delicate issue. We have seen, for example, in South Korea, a progressive bill going back because of disability, being part of the anti-choice movement. So progressively, the best ways sometimes we are pushing, I'll say as women's spaces, is try and bring on board disability women-led organization to be our allies, putting in mind we have been used by the anti-choice movement to have and to really bring down progressive laws and policies. So for example, Women's Spaces is trying to bring on board as much as women-led disability women-led on board to be allies of the reproductive justice movement, because the movement cannot move independently. We are the people to bring it down. Sometimes we have been used by the church, we have been used by the traditional leaders to say this is not acceptable in the society. But these are some of the ways we can maximize and bring the disability and the intersection together so that we can make the laws progressive. Thank you so much.
Thank you so much to Ali, Clara Rita, Agnieszka, and Phyllis for your interventions. And the organizers and prepared also some follow-up questions for you. And Ali in particular have a question from the audience. I'd like to remind the audience that there is interpretation for this call and that you can use the question and answer feature in Zoom to ask any questions you have to the panelists. And I'd like to ask a follow-up question to Ali, which is related to what you said in terms of the contrast between what's going on in the US and Latin America. And it is, what do you perceive has been the role of the political economy in shaping the last landscape on SRHR and abortions in particular? Also given the polarization on some of the issues that you mentioned that are arise in the different countries. So please go ahead.
So I also saw the question in the chat. I mean, my general response on the political economy is that there is a narrative that the wave in populism, which we see in Eastern Europe, we also see in the Philippines and in the United States, of course, and elsewhere, is simply sort of a clash in values. And I don't believe that narrative. I think that over decades of increasingly intrusive neoliberal governance. There has been a growing legitimacy crisis in our democracies and a growing sense that our economic and political institutions don't work for us. And I think that breeds a turn toward these populist leaders who pretend that they are going to speak and act on behalf of all of the common people. And that then quickly turns to otherizing and demonizing certain sectors of the population, which generally include women and pregnancy-capable people. So that's one aspect of the political economy shifting to the closing of civic space, the demonizing, the displacing attention from economic and social precarity to issues of sexuality that are very sensationalized, et cetera, and sort of the culture wars and the anti-gender and invented gender ideology. So that's one thing. I think as the person in the chat and you implicitly suggested, in Latin America, it's a more complicated situation because even though abortion began, abortion advocacy and feminists began working on this just as long ago as in the United States. In the early 70s, feminist activists were working on this in Latin America and around the world. But then there were, a series of sometimes dictatorships and sometimes other kinds of regimes that were anti-democratic. And this has been something that has been building for, as long as we've had the precedent of Roe v. Wade in this country, where feminists have connected abortion and reproductive autonomy and reproductive justice to broader issues of democracy, inclusion, that you can't have two systems, a democratic system and a rule of law for things that happen to men in the public domain, and another kind of system that denies pregnancy-capable people control over their bodies in private spaces. So I think that the kind of ways this has developed have been quite different in places that we're seeing populism and closing of civic space and a much longer history of seeing reproductive justice as part of a struggle for deepening democracy in the region. And to the question in the chat, I would say that the region has extremely strong transnational feminist networks. And by the way, in most of these countries, the feminist networks have also worked, it has not just been women, it has been LGBTQ movements and other broader movements. In Argentina, the labor movement was very important. So I think those networks have affected a much broader social decriminalization of abortion that we still have yet to really dig down and do in this country. It's still an incredibly stigmatized procedure, which allows antis to use it to displace attention from social and economic precarity. Okay, I'll stop and leave other people space to talk.
Thank you so much. Maybe in the meantime, you can take a look at the other question that's in the Q&A. While I move to ask Clara Rita, if you can speak a little bit to the role of law in advancing a framework of decriminalization for abortions and the experience as far as the recent legislative developments in the Philippines.
Okay, first I'll talk about what we did in the Philippines in terms of the title that we proposed. For example, in the bill to decriminalize abortion, it's a bill to decriminalize abortion to save the lives of women, girls, and persons of diverse gender identities. And since the bill mentions save lives, anyone who would oppose the bill would be opposed to saving the lives of women and other pregnant persons. So we were wondering why we did not get rabid opposition statements, for example, from the church and all. And probably we were thinking that because they would appear as villains if they opposed a bill that is trying to save the lives of women. So, and then I mentioned earlier that there was one senatorial candidate who supported decriminalization of abortion, and he was actually endorsed by a group of Protestant churches. And that is the first time that we've seen this. Although, of course, she's also a strong labor rights advocate, but still he was supported by the Protestant churches. In the past, in our history, we have been successful in repealing discriminatory laws in the Philippines, such as anti-subversion law, previously used during the martial law dictatorship against dissidents, anti-squatting law, previously used against informal settlers, and certain provisions in the colonial revised penal code penalizing vagrants and penalizing marriage of widows soon after the death of their husbands. And obviously, these are all discriminatory against either poor or women. And we have seen that this kind of repeal of laws are already veering away from imposition of penalties. And we're very hopeful with this kind of a history. We have a strong history as well of success stories in terms of passage of pro-women and pro-LGBTIQ laws, such as, for example, the anti-sexual harassment law, anti-rape law, anti-violence against women law in the Philippines, anti-trafficking, the reproductive health law. Although it took over a decade to pass, the Quezon City Gender Fair Ordinance, an anti-discrimination ordinance prohibiting discrimination based on sexual orientation, gender identity, and expression, and safe spaces, also protecting discrimination even on the basis of gender and SOGI. But all of these laws were passed together with the strong advocacy of the women's movement and legislators whom we were able to convince. But we also have examples of unequal protection of the law, such as until now, we are the only country in the world without a divorce law. And I would not consider the Vatican, because although they are a state, I would not consider them a country. We have still a restrictive abortion law. We do not have a SOGI equality law. We do not have a gender recognition law and no marriage equality law. So lastly, I'd like to mention that the issues on divorce, decriminalization of abortion, and marriage equality all became election issues this 2022 elections, although the outcome of the elections is very difficult for many of us who are against the dictatorship. But we have seen some strides, for example, these kinds of issues being in the forefront. But with us pitching these issues to the media and doing our work for the past few years as well. So thank you for now.
Thank you, Clara Rita. Next, I'd like to ask Agnieszka your opinion of what has been the role of social movements in mobilizing on the issue of decriminalization, and how has this led to more intersectional framing of the issue? You are in Poland, and when the decision came down, a lot of ableism came up in some of the public conversations. So love to hear your opinion on this.
Yeah, thanks, Andrea. So I think the role of social movements, and especially the role of cross-movement work, was really essential when it comes to like this mobilization over the past few years in Poland. And it was, of course, key to resistance and stopping this proposition when it came for the first time in 2016. But also, I think it was very key for like our self-reflection and also framing a more inclusive legislative proposition. And it also speaks to, for sure, to the sexual and gender diversity and the legislative proposition being much more inclusive of trans and non-binary persons, for instance. But when it comes to the intersectional framing around disability, the situation in Poland, I feel, was very much complex. And also one was exactly the premise that was turned out loud, but also it's also due to the fact that persons with disabilities are experiencing very much the reproductive stratification, right? So I think that what I want to highlight is that since the very beginning of the strikes, there have been continuous efforts to address ableism within abortion debates. And at that time, feminist disability rights advocates really tried to address ableist language and the way the abortion debate was being framed. However, I think it very much became clear that with the mobilization in 2020, voices of diverse persons with disabilities only got stronger. Exactly when the Constitutional Tribunal outlawed the premise allowing for abortion on so-called embryopathological ground, right? And during these debates, interestingly, much stronger were articulated also the voices, the pro-choice perspectives of persons with disabilities, but also these argumentations around asking on a very basic level to also focus on the rights of women and persons with disabilities, right? Not only center the discussion around fetus. So I think this was one of the articulations that were heard very much. But I also want to make this last point that if we look at those mobilizations from the reproductive justice perspective, I think what we see is that it is very often women and persons with disabilities who bring the reproductive justice perspective very strongly. They bring the demands around access to health information that is very often denied, information and access to contraceptives, freedom from forced sterilizations and abortions, right? Support in parenthood and counteracting the ableist prejudices, denying persons consent and decision-making, right? While this is being more and more recognized, especially efforts to offer support to persons with disabilities seeking abortions, it does not really translate yet to changing the agenda fully to comprehensively address ableism within SRHR movements and tackling ableism. So I think there is a lot still to act upon, and especially in the context where the stratified reproduction is very much experienced. Thank you.
Thank you, Agnieszka. And those points that you bring up are so key. We saw that exact dynamic with the Zika crisis in Latin America. And I think the question of ableism and in abortion is still a very live question. And Phyllis, I'd like to ask you as a follow-up question, how do you know when it is a strategic moment to push for decriminalization? And could you speak more on the intersection of disability and SRHR and how this has manifested in the move for decrim in Kenya? Thank you.
Thank you. I bet I'm audible. I believe I had shared this before. The best time is when you have progressive policymakers that are on board. And sometimes when we have seen when we are electing and nominating our leaders as a movement to try and see who is the best person when they go to the parliament for us to push for our agendas. works. This worked very well during the 2010 constitution amendments, when we had activists, more activists coming on board to the parliament compared to more of politicians. And that is the time when we actualized our, for example, the Disability Act, and that we saw progressive laws, and we saw that whoever had come on board has embraced and is trying to be a little bit more progressive. So these were the best times for us when we really pushed for our agendas. This is the time when we saw the introduction of the Article 26, which was not there before. Before, the Constitution of Kenya was saying that the Penal Code 158 to 160, we saw very well. Up to now, it is still there. We are seeing it criminalizing the person who's giving the services, me as the girl and the woman who's really getting the service, and anyone who sells me any drug to procure an abortion. But during this time, simply because we had progressive policymakers, that is the time we're able to introduce Article 26, where abortion now is being able to be given under specific conditions. However, we still see girls and women continue to die due to unsafe abortions, simply because the grassroots woman does not know what the Constitution does. So a lot of advocacy to grassroots movement and to women in the grassroots are being and making them take advantage of the situation. Right now, we are having the Reproductive Health Bill policy that the CSO took to court, and we say that this policy is not reflecting the women reproductive health services. We said the policy is not reflecting what is there for abortion. And what we had seen is the church trying to partner with the ministry so that they are able to really scrap off what we have made strides on. So the CSO, luckily, we were able to get the bill right before it was launched. If it was launched, it was going to serve us for the next 10 years, putting in mind it was not sharing, it did not have statistics, as Women's Spaces presented that we do not even have statistics for disabilities and how the indicators shall be reflecting for us as girls and women with disabilities. So what we have been doing as CSO is identifying who is on our side, who is progressive, how can we lay out our issues, how can we address our issues to people that are more progressive in the ministry compared to their others. However, we still face challenges. The church sometimes is ahead of the game. The anti-choice are ahead of the game. And we have, however, somehow we come to a compromise. And right now we are having a bill that was got back to draft and yet to be launched. Again, the intersection of disability and the reproductive and abortion continues to be a contentious issue. Why Africa being very traditional, surrounded by myths and misconceptions, how do we bring together, how do we make them to be allies? So the power for the movement is to bring disability movement on board, to be part of the reproductive justice. If we continue to push for our agenda in silos, our agendas may not be heard, our agendas may not come to actualization. However, if we move and have intersections, if we merge and bring synergies together, the intersection of disability, when forged together, may, for example, make the anti-choice movement slightly weaker for them to push out their agenda, putting in mind they use us as a tool or a weapon to have very laws and policies that are not progressive. So bringing the disability movement on board in the reproductive justice and having synergy now will help us achieve our goal of decriminalizing these abortion laws.
Thank you, Phyllis. I'm going to pass now to two questions that we have from the audience, and they are for any of the panelists. So maybe if all the panelists can turn on your cameras for this last part. We have a question from Maximiliana Rifkin, and they say, many times it seems like the abortion debate in the United States is framed in terms of the metaphysics of personhood. There is a debate over the threshold of fetal personhood, or the balance of harm in terminating a pregnancy versus violating a woman's freedom. For example, there is a debate over the weightiness of the obligation not to kill the fetus versus the negative freedom not to be forced to give birth. My question then is, to what extent are these same debates happening in other countries where the constitutions or political coalitions differ, as has been mentioned? If the debates in other countries are different, how are they different? So I wonder if any of the panelists have a comment about that question.
I can give a short answer. In the Philippines, it's the same. The anti-choice would argue on the rights of the unborn. Of course, we argue that the woman's right, or the pregnant person's right, would trump the rights of the fetus, for example. We also, and that's why we argue on things that we feel that the antis would be able to understand. For example, public health issues related to gender-based violence, issues related to lack of access, even for rape survivors, and the impact, for example, of lack of access to abortion, even for post-abortion care, patients, for example, needing post-abortion care, and even, for example, lack of access to misoprostol for other reasons, such as postpartum hemorrhage, where in far-flung areas, you need a misoprostol, which can be used as, of course, an abortive agent, but it can also be used to prevent and treat postpartum hemorrhage. So these are other issues that we raise that we hope will that the anti people would be able to understand, and not just issues related to fetal rights. Of course, I've already argued that all of the rights, from privacy, equality, non-discrimination, equal protection of the law, rights against torture, these are all very important argumentations.
Thank you. Do any of the other panelists have a comment about that question?
I can just add to that, that from the context of analysis, like feminist analysis on the discourses being used in abortion debates, I feel that we of course observe kind of similar framing, but also some of the analysis also around like how the abortion debates were being held in the communist period in Poland. They were showing that there was also much more emphasis on the dignity, health, and social accountability versus the framing that that you were mentioning. So so also wanted to highlight that, and also there's been like much more embeddedness in this discourse around secularization versus kind of religiously informed societies.
So I think I sort of did answer this question, both in my presentation and in a response in another question in the chat, but it's definitely goes with the privacy framing and sort of sectioning off this idea of the maternal fetal conflict from the decisions that women need to take, which are embedded in a web of relationships in their lives, has certainly been problematic in the United States. And as I and others have said, there are additional and other framings that have, although that's still present in the debates, that have really advanced reproductive justice in other ways in other countries.
Phyllis, is there something you would like to add to the question?
No, I think they've shared comprehensively. Thank you.
The other question is posted in the chat by Blas Radi, who's a panelist in the second panel. And it says, at times, it seems that reproductive justice tends to be reduced to the right to abortion for certain women, cisgender, able-bodied, white, and eventually trans people, people with disabilities, and women of color are included into the same agenda. What do you think about that? Is there anyone who would like to speak to this question? Phyllis?
Yes, I think that statement is very true. In our context, our structures are very ableist, and we see, for example, us as girls and women with disabilities not able to access services equally as our fellow women, simply because we have disability and the structures have not been targeted for us. So while accessing these services, you find that they're not friendly, either we are not able to afford them, either they're not accessible, either they're not even affordable to us, because not everyone, for example, is able to afford, for example, an abortion service. In Kenya, sometimes it could be expensive. What about me as a girl who's in the formal settlements and I need an abortion service? Am I able to pay the $100 or the $150 that another woman from another class is able to pay for this service? When I go to the health clinic, am I able to get the contraceptives? Sometimes in Kenya, we may not have all the contraceptives, and I'm told, come another day. I'm in crutches, I'm on a wheelchair, I'm depending for someone to take me to the health clinic. Someone has had to take a day off to take care of me, to take and escort me to the clinic. And when I go to the clinic and I'm not able to get this service, what happens to me if my guide is not able to, for example, escort me another day? It means I'm lacking these services. I agree with that statement that some of these structures have been abused, and sometimes we, the minority group, may not access all the services accordingly, like our fellow peers. Thank you.
Thank you, Phyllis. I find that besides access, there are certain specific debates that the feminist and reproductive justice movement are not paying attention to, like the question on legal capacity and how consent is built, and the reforms on legal capacity rarely have feminist input from the movement, even though is one of the key aspects on how forced abortion and forced sterilization take place for folks with disabilities. I wonder if someone else would like to comment in response to that question.
I'd like to add, Andrea. I agree that oftentimes the argumentation for access of trans people, persons with disabilities, is not immediately like the first argumentation, but as of now, you will also see that we are trying to be inclusive as well. So given the bill in the Philippines, we use persons all along the same line: women, girls, and persons of diverse gender identities. We try to use pregnant persons as much as possible. But in the argumentation as well, because for some people, gender is still not widely understood up until now, we try to frame gender to include issues of persons with diverse gender identities and even diverse SOGI, for example, lesbian women, bisexual women, transgender men would have access issues in terms of lack of access to safe and new abortion. And so we are also trying to reach out to LGBTIQ people for them to be able to join us in the advocacy. And we're seeing now that a lot of transgender women are actually even the ones who are strongly advocating together with us. And we need more information dissemination for more people to understand that this is not just, for example, an issue of cisgender women, but an issue of people with diverse zoology as well.
Thank you, Clarissa.
So,
Alicia.
Sorry, I would just say, I mean, I agree with everything that's been said, and I am, and I don't want to in any way paper over what I think are pretty deep fissures in different feminist movements with both LGBTQIA+ movements and disability justice movements. But I do think that there are differences among contexts that we need to understand and acknowledge. And I also think that the problem, the obstacles to access go way beyond abortion, right? And reproductive justice is not just about abortion. It's there are obstacles to access based on ableism and based on sexual binaries that affect all kinds of social determinants of sexual and reproductive health.
Because of course we remember about the roots of reproductive justice framework and how we learned from it and who we learned it from, right? So, but it's also, I think, what was shared by one of the panelists also, I think it's very important to take into account, like, how do we implement this concept in our work and in our own societies, and what access of inclusion, exclusion we need to take into account, being based in particular geographical and cultural locations. So I think I just feel that reproductive justice concept is like this utopian concept that drives us to a certain place, but unfortunately the different axes of oppression in the society are still being present. So this is maybe how I approach that.
And there's a question that is related to this specific topic from Valika. And they say, when it comes to reproductive rights, especially trans and non-binary bodies assigned female at birth, one of the possible effects I expect to see is dysmorphia due to the association of pregnancy with femaleness. Therefore, my question is, 1, how has this movement contributed towards this? And 2, what more do you think should be done? Is there anyone who would like to address this specific? I think also this comes highlighted in a specific moment where the fracture within the feminist movement is very clear, with people who take on transphobic positions as feminist positions.
I don't want to take too much space, but if I have to start us off, I think of course, we need to, as feminists, we need to like reclaim that feminism is anti-transphobic, of course. And but I think that on a practical level, from my context, what I feel is important is to also go beyond language. So I think that there is a lot of work being done to use the inclusive language, but also still, as the question has correctly pointed, right, there is also the level of services, also the level of social movements, also the level of access to certain information, etc. So I think, like, with regards to this question, like, what is there more to be done? I think it's also to really much embed our approaches in practice, not stop on the language and discursive level. This is maybe to start us off.
Mm-hmm. Thank you, Agnieszka.
I mean, I would again reiterate what I said before, which is I think this is a very real problem and issue. And I think it's difficult to answer in the abstract because it will play itself out differently in different social contexts, health systems, et cetera. So, but I think it's a real problem, and there's certainly a lot of fault lines, as you pointed out, Andrea, about transphobic feminism in this moment in many countries.
Yeah, and I think one of the ways in which it plays out is that we haven't talked much about is imperialistic ways of turfism from the north influencing global south ways of social movements, particularly from the UK and the US. There's another question in the chat, an anonymous question, back to the question of criminalization that says, how do we think about abortion with an anti-carceral framework? Why should abortion be fully decriminalized and not partially? Some countries retain penal provisions for forced abortion to provide protection to women against domestic violence, for example.
Okay. In the Philippines, what we're pushing for is full decriminalization of abortion. And also we're saying that even the provision on forced abortion will not be penalized under abortion, but other existing laws, for example, physical injuries, etc., mutilation, etc. So, and the angle here is that we want to eliminate the stigma on abortion without saying that forced abortion will not be criminalized, meaning to say it will still be criminalized, but under existing laws.
And do any of the other panelists have an issue here to respond? Maybe Phyllis?
Yeah, I think why we must fully decriminalize abortion, it's because women's lives matter. Abortion is healthcare. It is our right to get abortion services. Girls and women continue to die due to unsafe abortion and due to these restrictive and abortions that criminalize women, health providers, or even doulas that support women to have abortion. For example, Agnieszka talked about Justina, part of the abortion dream team, who's now is facing charges, possibility of getting time in jail simply because she sold abortion pills to a woman who is, of course, over 18 years, is able to make decision over her own body and has a right to procure an abortion. Then simply because the partner decided to raise an alarm and say, my partner, my girlfriend has procured an abortion and so sold these abortion pills. Sometimes as a feminist, I tend to think, what if it was the other way around? What if we are losing another group of people due to unsafe abortions? Will these laws be restrictive like this? Will we still be losing this other party population the way we are losing women and girls? We must hold the bull by its horns. We must tell our policymakers that girls and women's lives matter. It is our right, and we need our rights to be addressed equally like any other rights. We cannot give people rights, but still say we are giving rights up to this point. And after this point, now we are again denying you the right. So as much as us, the CSOs, for example, in Africa, we are trying as much. It might take a while for us, but the fight has to continue because we are losing so many lives due to unsafe abortions. Thank you.
Thank you, Phyllis. Yes, of course.
So this should be obvious to everybody tuning in, but criminalization of abortion does not reduce abortion. And that has been documented empirically all over the world. So that's I guess the first thing. And I completely endorse everything Phyllis said about women's rights. But the second thing that criminalization does is that it weaponizes health systems against pregnancy-capable people. So when there are criminal penalties imposed, except for certain exceptions, those have to be interpreted by health providers, and there's often fuzziness around, is this a severe threat to the health of the woman or not? She might have cancer and need to undergo treatment, but she would, there are lots of questions, and it has a chilling effect on health providers and on the relationship between health providers and patients. There are reporting requirements often in general health laws that require health providers to turn in people trying to obtain abortions. And we've seen this even with people who are experiencing obstetric violence or miscarriage, that they are then criminally prosecuted. So it has a corrosive effect on social institutions and the ability to assert to carry on, to manage the health system as well as on the rights of pregnancy-capable people.
Thank you, Ali, for making those points. It is a whole system that gets impacted when using criminal law to advance rights, and it's also the most populist way we see for decision makers to use to push for political buy-in. I wanna thank you, Agnieszka. Did you wanna?
Yeah, just wanted to add one point around, because it was in the context of enforced abortion. I understand this question was put. So I just wanted to say that I think that there are also other tools to really address this very important issue of enforced abortions or enforced medical procedures, right? And also one of the arguments against partial decriminalization would be that, of course, not all of the groups in the societies are being tackled by criminalization in the same way, right? So we also need to have that in mind. So yeah, just wanted to add that.
Thank you, Agnieszka. And also most of the forced abortion and forced sterilization of people with disabilities happen legitimized by the state under guardianship laws. It's not like the criminal does anything about those forced abortions or sterilization. And it makes me think also of the whole discussion on punitivism used by feminism, and also current discussion happening on obstetric violence. That's pretty key, and that is just beginning. I want to close this panel now by thanking all the panelists for their wisdom and the key points you all shared in this conversation. And I want to give way to the second panel that's going to enrich the conversation very much. Thank you to all the organizers and the interpreters for making this space more accessible.
Thank you so much.
I'm just going to maybe invite all our speakers for the second panel to online. And I just want to convey in the meanwhile my gratitude to the first panel for opening us up so wonderfully with so many thoughts that I feel will have a lot of resonance with the second panel. And it was really a riveting evening. I was midway making my notes when you ended, so really grateful for that. And so if I could invite Maithili, Nikita, Blas, and Maria. As they come online, let me waste no time and introduce each of our speakers for this evening. We have Maithili Srinivas, who's a professor of history, women, gender, and sexuality studies at Ohio State University, and has recently written a very important book on reproductive politics in the making of modern India. We have Nikita Sonamane, who's an advocate in Bhopal and the co-founder of the Criminal Justice and Police Accountability Project. We have Blas Rade, they're a researcher at the Argentinian Society of Philosophical Analysis, and for the past decade or so have been working on challenging reproductive injustice, particularly when it comes to trans people. And finally, we have Maria, who will have to forgive me because I will not be able to pronounce their last name. But Maria works on with the Real Productive Justice Project at the Center for Disability Law and Policy, and is a founding member of Disabled Women Ireland. And so in this panel, we will be mostly kind of thinking about the move from reproductive rights to reproductive justice. We might speculate about what it might mean to move towards reproductive justice outside its history with Black feminism and the global North. And finally, as like much of the first panel kind of suggested, that a lot of the issues around reproductive autonomy and rights often come with a bunch of other issues, whether it is the kind of attack on LGBTQI populations or on other kinds of conservative policies. So one of the things that this panel will really address is something called intersectionality, which we did touch on. I have to apologize. I've just been informed that Nikita couldn't make it this afternoon.
No, sorry, Vicky, they're going to join. So I think we'll just wait for another 10 minutes. We were supposed to start at 7:40. Apologies for this interruption.
Okay, no problem. So we'll just wait for Nikita to join us. But maybe in the meanwhile, we'll leave the floor to Maithili for opening comments. I would highly suggest that everyone speaks really slowly so that it makes it easier for the interpreters. As the last panel went, each person has about 6 to 8 minutes to give opening comments, and then maybe we'll go through a round of discussion amongst ourselves. And finally, we leave it to the audience. The audience can come in at any point with questions or comments in the Q&A box at the bottom of the screen. So without further ado, Maithili Srinivas.
So yeah, thank you so much. And just to clarify, we are starting now, right? We're not waiting the 10 minutes. I was just getting mixed signals.
So may I please request that if you could wait for another 5 minutes before we start with you?
Okay. Sure,
that Nikita isn't here, and we announced on the in the last panel that we would start at 7:40. So our interpreters aren't here as well. Apologies.
Okay, I didn't catch that. I'm really sorry for that and for that confusion, Maithili. So maybe we'll just wait 5 minutes. Everyone can get a glass of water, and it can be an access break in the meanwhile. We reconvene in 5 minutes. Hi, Nikita.
Hello.
Hello. We were just waiting for you. So we said that we would start in 5 minutes, about 3 minutes ago. So we're just going to wait another 2 minutes. Everyone reconvenes and then we'll start. I've already done the introductions for the panel. So we will go in the order of Maithili, you, then Maria, and then finally Blas. Right?
Okay.
Speaker has about 5 to 7 minutes to give opening comments. Then we go through a round of conversation amongst ourselves. And finally, we'll leave it open to the audience, who will be asking questions in the Q&A box at the bottom that I will happily read out to all of you.
Yeah.
So in just 1 more minute, we get started. Sounds like New Year. Okay.
Does.
Okay, welcome back everyone to this to the second panel of this really important conference on reproductive justice. And without further ado, I hand it over to our first speaker this evening for their opening comments, Maithili Srinivas.
Hi, thank you everyone. And thanks so much for the invitation to be part of this really important conversation. I'll just jump right in. So I was raised and live in the United States, and my scholarship as a feminist historian is focused on India. And living and thinking in this dual space has made it apparent to me, and I'm certainly not the only one, that the expansion of abortion and contraceptive access is not necessarily an expansion of reproductive justice. Both in India and in the United States, the liberalization of abortion law has occurred alongside the growth of a feminist movement and movements for liberation on the one hand, and of population control, eugenics, and the intensification of patriarchal state power on the other. We can understand these these sort of dual directions most clearly if we center the lived experiences of marginalized persons. To say this differently, an intersectional analysis can illuminate what may be oppressive, even within claims to liberalize the laws pertaining to abortion and contraception. Historically, the concept of reproductive justice emerged from this tension, the recognition that a liberalization of law was not necessarily an expansion of rights, and that what might appear as an expansion for some social groups was inseparable from the intensification of reproductive oppression for others. So as you may know, the term reproductive justice was put forward in 1994 by Black women activists in the United States who organized themselves as Women of African Descent for Reproductive Justice. Soon thereafter, the organization's sister song, Women of Color for Reproductive Justice, was created to nationalize the movement. Sister Song defines reproductive justice as, and I quote, the human right to maintain personal bodily autonomy, have children, not have children, and parent the children we have in safe and sustainable communities, end quote. I'll return to what I see as the radical potential of this definition in just a minute. But first, I'd like to share one historical example, because I am a historian, that clarifies what a reproductive justice concept offers to our understanding of sexual and reproductive rights and health. Abortion was legalized in the United States, as you know, via the Roe v. Wade Supreme Court decision in 1973. It was decided both in the context of a growing feminist movement and in the context of a growing global and domestic campaign for population control. While Roe liberalized abortion law, it did not address another major form of reproductive oppression that was born of population control legacies, the practice of coerced or non-consensual sterilization of women and pregnant persons among indigenous communities and communities of color. These sterilizations included pressure on pregnant persons to consent to the procedure while in labor, pressure to sign so-called consent forms in English when a person did not know the language, and the practice of routine sterilization with limited or no consent by the Indian Health Services that led to between 25 to 50% of Native American women being sterilized by 1976. However, when Indigenous and women of color groups organized in the 1970s to demand more aggressive regulation to prevent such abuse, they did not receive support from the mainstream white-led abortion rights organizations. Many of their white middle-class membership had not experienced pressure to be sterilized, but rather the opposite. White women seeking voluntary sterilization faced difficulty in getting medical professionals to agree to the procedure. Mainstream groups, including Planned Parenthood and the National Abortion Rights Action League, took the position that increased regulation would deprive women of the freedom of choice to select voluntary sterilization. Women of color and indigenous groups argued that their reproductive choices had already been hollowed out by ongoing oppression of class, race, poverty, loss of sovereignty. They called for a tighter regulation of sterilization as a means to resist the injustice they faced as members of communities whose reproduction had been stigmatized. So I dwell on this example as a kind of cautionary tale, an example to help us understand how a supposed liberalization of laws on reproduction, in this case on sterilization, was not necessarily an expansion of rights, dignity, or justice. Ignoring this fact led to a fracturing of feminist movements in the United States and a narrowing of reproductive rights to a fight for abortion only. And I dwell on this example because it was incidents like these that prompted Black women activists to develop the concept of reproductive justice in the first place. It came not just from a push to liberalize abortion law, but from wider struggles against eugenics, population control, racism, settler colonialism, alongside gender oppression and misogyny. And I think that wider history is what makes reproductive justice a capacious term that may be relevant outside the US women of color context in which it was first emerged. So just to wrap up here, I want to return to the definition of reproductive justice as articulated by Sister Song, right? The right to have and not have children emerges from the history I just outlined. However, it's the last part of the definition that's the most radical and transformative. That's the right to parent the children we have in safe and sustainable communities. I have 30 seconds left and I'm going to get my last sentences in here. This is an expansive vision, right? A safe community is not at the mercy of a carceral state. It does not face police, military, racist, communalist, or casteist violence. A safe community also challenges an ableist and eugenic devaluation of life. And a sustainable community attends to environmental racism, to the seizure of land and sovereignty from Indigenous and Adivasi communities. It imagines more than human worlds. So for me, it's this last part of a reproductive justice definition that points the way to an intersectionality, not only of identity, but also of solidarities of struggle among a wide range of movements for social justice. So I'll wrap up there.
Thank you, Professor. Nikita, if we can have you.
Hi. Am I audible? Thank you. Thank you for inviting me to be a part of this very important conversation. I think my sort of intervention into thinking about questions of reproductive justice are within the Indian context, and of course, largely through the realm of what is it that criminalization and the criminal justice system and it's the sort of criminal legal framework and a critique of that would mean for questions of reproductive justice, right? And And I think in India, particularly, with whether it's reproductive justice or a lot of questions of sexual violence and harms of all kinds, for instance, have been rooted within the realm of criminalization. And I want to talk a little bit about the question of abortion in India, because I think that sort of reflects the way in which the criminal justice system or the realm of criminalization has been constructed around reproductive rights, reproductive justice in India, right? So we have the Medical Termination of Pregnancy Act of 1971, and of course a bill which later became a law that came about later, which said that we want to increase the gestational period for carrying out termination of pregnancy, as the law calls it, or abortion. And so it increases that sort of gestational limit from 22 weeks to 24 weeks. And I mean, I want to begin by highlighting that this is a law that only seeks to facilitate abortion for cis women. So I want to proceed with that caveat. And of course, any sort of framing around the law or the amendment is something that hasn't, it needs to be a consultative process with the pregnant person. But of course, any sort of consultation around, whether it was the 1971 Act or the 2014 bill, or even the bill that was introduced during the pandemic, it was all drafted under a cloak of secrecy, and it did not, of course, reflect on the rights of important stakeholders or their perspectives, including sex workers, Dalit, Adivasi, Bahujan groups, trans persons, disability rights groups, medical survivors. So the sort of reason for encapsulating that kind of framework, I mean, is that none of this is a rights-based language, right? So in order to carry out termination, it is permission from a medical practitioner that is required even within a gestational period. And so it's important to understand that, criminal law or the criminal legal framework is one that is used to impede access to reproductive rights. And then, of course, there is the Indian Penal Code, which is criminal law that's a colonial sort of construct, which further penalizes with about 7 years of imprisonment, punishment for anybody who is inducing miscarriage of any kind, right? So I want to talk about, that there is this extensive criminal legal framework that we've been saddled with, and what are the kind of implications that it has, of the implication of relying on a criminal law framework that has for reproductive rights, right? So now the criminal justice system in India, and whether it's the institution of policing, is a colonial system, it's a colonial construct, and one that in the Indian context has sort of replicated itself around the Brahminical framework, which is the framework of the caste system, where there are certain communities that are considered where occupation is assigned by birth, and certain communities that that yield more power as a result of their position within the caste system. The highest caste being the Brahmins, which is the priestly caste or the intellectual class as caste as it is understood by the caste system. And I mean, it also includes a lot of communities that fall outside of the caste system, that includes indigenous communities or tribal communities that were classified as criminals by birth by the British, or known as, or born criminals known as denotified tribes, right? And the reason that this context is important, because we want to see how those who are at the lowest rung of the caste system, or the so-called low caste, or those that fell outside the caste system, they needed to be controlled and disciplined by the law. And this is the sort of history of criminalization. So I want to highlight this and sort of drive this point home. That any kind of intersectional analysis in the Indian context has to be cognizant of the fact that within the Indian subcontinent, the question of caste or caste is the genesis of power, right? So any sort of intersectional understanding has to stem from the understanding of what is the genesis of power within the Indian context, which is that of caste. And I want to locate this attempt to discipline or control the bodies of certain people, particularly people belonging to the so-called lower caste communities through criminalization, whether it's abortion, forced sterilization, and locate this within the larger context of reproductive politics and see how this is a way in which the law is relying on Brahmanism, and it is the disciplining of certain bodies in line with the Brahmanical structure that we're looking at, right? So the sterilization program, there were mass sterilization programs that have been carried out in India in the 70s during the emergency period. And even after that, sterilization has been a major focus of the Indian state for quote unquote population control. And it's an entirely unregulated space, and there have been several deaths due to washed up sterilizations that have happened. And unsurprisingly, it has been of mainly women that belong to the Dalit community, which is a community that were classified as former untouchables, Adivasi communities, tribal communities, and other oppressed caste communities, right? So in India, and in so many ways in India, the idea is that reproductive health is synonymous with family planning. And this program hinges on saying that, we need to limit the size of the family, we need to control the population, and it's going to happen through carrying out sterilization and controlling the bodies of those who belong to Dalit, Bahujan, Adivasi communities, particularly those that identify as non-cis men, right? And I think it is this sort of framing of reproductive rights within the institution of family and within the institution of population control that is useful to understand. Now in India, there's also, like I was saying, a clear sort of penalization of not just controlling of bodies through programs like the sterilization programs, but also reproductive rights, or the sort of framework of reproductive health has also become a sort of garb of using criminal laws to control the sexualities of certain people that belong to certain communities, right? So we see this very commonly, as someone who's a practitioner of criminal law, we see this law that was passed in the year 2012, which is the POCSO, which is called the the Prevention of Child Sexual Offences Law. It's a law that was passed to, stop child sexual abuse. And we've seen that a lot of cases under this law that was passed to control child sexual abuse have been, have been registered, or have been, the people that have been incarcerated under these laws are really young adults within the age of 14, 15, 16, who have been in intercaste or interreligious relationships, couples that have resorted to elopement or resorted to, running away from families to get married. We've seen this law being utilized very commonly against them, right? And a lot of these intercaste and interreligious relationships and criminalization under POCSO is therefore then of people that, men particularly that belong to oppressed caste communities. And we've seen that, because POCSO has this provision which says that, you have to mandatorily report each time. So if a woman, if a minor girl walks into a clinic and says, she wants to get an abortion, it just means there will be mandatory reporting to the police because she's a minor. And what that essentially means is that you see that immediately it means the criminalization of the men in those relationships, because consent as a category ceases to be relevant when you're under the age of 18 or a minor under Indian law as you consider it, right? So you see that, we had one case where we saw this very clearly, where a minor wanted to get abortion, and the father, as the guardian who could sign off on that abortion, said, well, I'm not going to sign off on this abortion unless you testify against your lover in court under the POCSO Act, right? So you see how criminalization and reproductive rights then becomes is then reduced to the mercy of criminal law. And I want to talk about how this controlling of bodies, particularly of women, because within the caste system and Brahmanical patriarchy, it is the sexuality and the controlling of the bodies of women, and particularly in the cases of POCSO, the women, that are in these relationships are usually women that belong to oppressor caste communities or the so-called upper caste communities. And you see how criminal law is then weaponized as a tool to control these bodies and control the sexualities of women, right? So I want to talk about like how therefore it is important for us in our sort of approach of any kind of anti-carceral critique of reproductive rights or thinking about questions of this. Sorry, I just realized I have 30 seconds to think through these questions and think through and in so many ways center the question of caste, because any kind of anti-carceral analysis of the criminal, any kind of analysis of reproductive justice is incomplete without an anti-carceral analysis of it, and any kind of anti-carceral analysis in the Indian context is synonymous with the an anti-caste analysis. And I think that's what I want to close with, and hopefully as the discussion progresses, we can flesh out some of these questions further.
Thanks for that, Nikita. Maria?
Yes, thank you. My head is buzzing between the listening to the other panelists from the last two panels. So I will try and keep to time, and I will try to speak slowly, but I may struggle. So please do remind me if I'm failing on either of those things. So in some respects, one of the questions in an earlier panel broke my heart, as it essentially said, how can we make reproductive justice about something other than white, non-disabled, heterosexual, privileged women having abortions, when reproductive justice was something that was never supposed to be about that, was an answer to a reproductive rights movement that had only been about that. But what I think we've seen, particularly over the last 10 years, as people might be more aware of intersectionality but unwilling to do the work involved in it, what we've seen is white, cis, non-disabled women who are straight, who overwhelmingly from the global north, turn around and say, oh, we're talking about reproductive justice now, and continue just to talk about their own access to abortions in a lens that doesn't actually extend reproductive justice for anyone. For me, reproductive justice is a completely clarifying statement that I suppose answers the call that marginalized voices had been looking for within reproductive rights, by saying, you know, it's the right to have children, the right to not have children, and the right to be completely unequivocally supported in those decisions, whatever they involved and whatever that involved. And it was the answer to a failure, the failure of a movement, but also the failure of law to fully recognize what was necessary there. And the law did fail. We're all currently mourning over Roe and also rollbacks in Poland and other states. But what we saw with Roe is that certain kinds of abortion rights are ultimately meaningless, because Roe didn't guarantee you access to an abortion if you were living in a rural area, if you were poor, if you were a person of color. If you lived in rural Alaska as an Indigenous person, or you were living in rural Mississippi, Roe was nothing for you, because the law wasn't actually an enabling factor. And what we've actually seen under Roe time and time again is at a state level, criminalization of people seeking termination of pregnancy services, or of people miscarrying, or of people's pregnancies, or doing things with their bodies. So it never actually caused that freedom. So the law hasn't really been an enabler in many circumstances. What we have seen be incredibly powerful is decriminalization. And I know in Ireland in the north, where we have full decriminalization but very limited access to services, communities, in particular communities of like activists, have been able to step in where the state has failed. Whereas in the Republic, where there is only partial decriminalization, access is patchy, but you haven't seen those activist communities be able to step in. But I want to ask another question as we're going through today, because while we can talk about abortion law or family law or the laws governing our health and our bodies and our families at length, if we're truly to answer the call of reproductive justice, I think we need to look at what other laws and other power structures that we need to be able to unpick and dismantle in order to fully meet the promise held within that phrase. And from disabled people and from the perspective of disability rights, the law was never designed for us. We talked a bit in the previous panel about that about the residual criminalization as a way to prevent forced abortion. And as was pointed out by Andrea, the state's probably in on it if someone is having a forced abortion. The fact is that the state is much more willing to endorse an abortion where the person accessing a termination of pregnancy isn't consenting to it or is actively rejecting it. It tends to happen in a sphere where the state is actively encouraging it in a way that we just don't see when other people are taking control over their own bodies. And I'm going to take a couple of examples just from Ireland, from my own context, where what we've seen being the real barrier to abortion, where the law says it's okay, isn't actually the termination of pregnancy law, but other laws governing disabled bodies, disabled minds, such as laws governing legal capacity, where, in 2017, we saw an asylum seeker who sought to have a termination of pregnancy because her life was at risk due to an emotional crisis. What happened to her was the law would have said that she would have been allowed a termination of pregnancy, but because her body or her mind was just unacceptable, the response was to use mental health laws in order to coerce her, in order to force feed her, in order to force her to continue out having a pregnancy. Alongside that, because she was a migrant, because she was an asylum seeker, because she was a refugee, she was unable to travel and access the other forms, was unable to travel, and borders themselves, something we don't talk about enough in reproductive justice, the border acted as a barrier to her accessing a termination of pregnancy. Similarly, an unnamed woman also in 2017, it was a rough year, maybe 2016, who was a child, was also experiencing a risk to life because of pregnancy, sought to access a termination, while the treating physicians completely ignored what she was asking for and denied her a termination of pregnancy. Again, because she presented as disabled, what they were able to do in that instance was use the Mental Health Act to detain her until she was not only able to access a termination of pregnancy in Ireland, but wasn't able to access a termination of pregnancy in the United Kingdom. So we see these laws being used in really pernicious ways in order to control our reproductive choices. So we need to be able to respond to that in meaningful ways that unpicks all of these power structures and all of these legislative structures that undermine our autonomy and our reproductive decision making. Last year, a woman who was in, now that we've completely reformed our laws on abortion in Ireland over the last few years, what we've seen is instances where often intimate choices about method of birth are denied to disabled women. And we've seen last year, we saw a woman of color who was in prison and disabled was forced to have a cesarean section without her consent because her say over her body was less. It wasn't our laws about abortion or reproduction that was governing this. It was other laws that were ultimately disempowering people. So we need to be mindful of all of these structures. I've gone over time, so I will stop now. I'm so excited, and hopefully we'll be able to have more questions and chats during the questions.
Thank you so much for keeping the time, Maria. And now if we could have Lars join us.
Hi, everyone. It's my turn now. I'm going to share my screen. I'm sorry for my voice. I'm dying here. Well, I am honored to be here today and to address the question of reproductive justice. I will make some distinctions regarding its form and content. First, at least as I understand it, with respect to form, reproductive justice is a complex and multifaceted phenomenon that includes a theoretical approach, a praxis, a movement, and an emancipatory horizon. So we can think about it as a composite unit that includes all these dimensions. Second, to make distinctions regarding content, philosopher Sally Haslanger provides a conceptual toolkit that can be relevant for our purposes. She distinguishes between the manifest concept, the way we define the concept, and the operative concept, which corresponds to the way we actually use it. So in these terms, I will break down my answer to be able to specify what reproductive justice is in manifest terms and what reproductive justice is in operative terms. considerations of this second concept requires, among other things, descriptive work based on an empirical input. And in my case, my analysis is anchored in Argentina, where I live and work. However, I believe that my conclusions are not restricted to this country. Regarding the manifest concept, of course, we can take Rose and Sollinger's characterizations, who, in addition to referring to rights, point out that at the heart of reproductive justice is this claim: all fertile persons and persons who reproduce and become parents require a safe and dignified context for this most fundamental human experience. Achieving these goals depends on access to specific community-based resources, including high-quality healthcare, housing and education, a living wage, a healthy environment, and a safety net for times when these resources fail. Here we can look at what it means for reproductive justice to articulate reproductive rights with social justice. It means repositioning those rights in a political context of intersecting oppressions of race, gender, class, and so on. In these terms, reproductive justice does not only refer to the right of cis women not to have children. First, because it is not just about rights alone. Second, because it's not only about abortion. And third, because it is not only about cis women. And as an emancipatory horizon, to speak of reproductive justice in this sense is to speak of a scenario of social justice where not only cis, white, and bourgeois women, but all people have the possibility not to reproduce, but also to do so and raise their children with dignity in a safe, healthy, and supportive environment. This means an environment free of poverty, discrimination, war, educational inequity, job instability, healthcare disparities, and so on. So getting to the point, to speak of reproductive justice in this sense is to speak of a movement committing to a holistic and intersectional lens that challenges the way we have traditionally thought about various issues, including, of course, reproductive rights and LGBT rights. If we think about it, this involves challenging both the limitations of these rights and the problematic commitments of the social movements that promote them. Let me explain what I am referring to here. Historically, LGBT rights have not taken reproductive rights and health into consideration. Trans rights in particular have tended to prioritize identity-related issues, sometimes in a way that seems to reinscribe that characteristically modern binary between mind and body and focus only on the former, as if these identities were not embodied. And considerations of the body, if any, tended to focus on aspects of what might be called transitional health, that is, gender-affirming surgeries and hormone treatments. As for reproductive rights and health, they have usually been thought of as women's rights. As A.J. Lowick have highlighted, reproductive health system, and we can add rights, were born out of an impulse to challenge androcentrism. They were created by and for cis women, but they don't necessarily work for trans people. And this gives rise to the second point. We saw the definition of reproductive justice, but is this the concept of reproductive justice actually at work in our institutions and social movements? I am referring here to the concept that emerges from localized relations between institutional apparatuses, programs, devices, rules, protocols, etc., where public authority is largely exercised and that make up the daily functioning of the composite, incongruous, monstrous reality that is the state, and also to the bills, declaration, programs, agendas, relations, coalitions, and more or less explicit commitments of social movements. I have been working for this issue for at least 10 years in Argentina, and well, we can organize these research findings into three axes corresponding to three reductive phenomena: the reduction of justice to law, the reduction of reproductive rights to abortion, and the reduction of the subject of this right to cis women. Well, in the slides, you can see one of the banners used by the Green Flag movement in Argentina. It says, "Not one more woman killed by clandestine abortion." In Argentina, the right to abortion has been the main protagonist, if not the only one, in the fight for reproductive justice. And it was defended as a woman's right. I say defended because feminist and women's movements, like the ones in the slide, did everything they could to ignore and belittle trans and non-binary people as subjects with reproductive capacities. I emphasize this because for me, more than 10 years ago, when I first became involved in these issues, it was an unexpected curiosity. But their adherence to the movements and their tenacity led me to take this phenomenon in a different way. It became the first finding in an extensive research process and was the thread I began to pull on to examine and try to dismantle the resistance to guaranteeing trans people's reproductive lives. And this led me to work extensively on the idea of male pregnancy in terms of a particular epistemic injustice, a case of hermeneutic injustice, in which there are concepts that allow us to make sense of this experience, that is male pregnancy, but they have no circulation due to various mechanisms of what we can call active ignorance. So mainstream reproductive rights movement has increasingly narrowed its concerns to defend almost exclusively the legal right to abortion, further distancing its agenda from the interests of those who have been and are victims of forced sterilizations or the dismantling of welfare programs and the public health system. Trans people, as you know, have been and still are victims of eugenic policies, whether active or passive. One of the theses I have defended in my work is that given these conditions, trans people are forced to choose between their human rights. It's a kind of extortion. The exercise of the right to gender identity implies the renunciation of our reproductive rights. In Argentina, public policies on reproductive health are oriented to women and designed with women. So even in a context for women, so even in a context such as the Argentinian, where a progressive legal framework on gender identity rights and also on reproductive rights is celebrated, we find that the nexus between women and reproduction is interpreted as obvious and necessary, while the reproductive life of trans people is still unthinkable. So while reproduction remains an inescapable social cultural mandate for cis women, for trans people, it is still forbidden, among other things, because reproductive justice continues to operate in this restricted sense. So we find this mismatch between the manifest concept and the operative concept. And now what? What should we do? Well, according to Haslanger, this creates an opportunity to ask the question, what exactly do we want this concept for? What function, if any, do we want this concept to fulfill in our thinking, but also in our world of practices and institutions? This question is answered with what she calls the target concept, the concept that we should be using given our objectives. And here I would like to open up the question, what do we want the concept of reproductive justice for? Answering this question requires a collective exercise in transparency. We have to make explicit what our objectives are. And it also requires a kind of reflective exercise that allows us to identify where our general principles are aligned with our mandates and our actions. The method of reflective equilibrium can be helpful here, particularly in the version of the Argentine philosopher Moira Perez that makes it a practical principle. She says, reflective equilibrium aims to assess the consistency within our set of general principles and between this and our ethical assessments of specific actions we pursue or advocate. It may happen that as a result of this exercise of reflective equilibrium, some strategies that in principle we consider ethically correct may turn out to be contrary to other principles that we also defend, which should lead us to review and redesign our belief, and I say, and actions. Thank you.
Thank you, Klaus, for that. And especially as you are quite significantly unwell, for you to make the effort of this, and thank you. And I maybe all the panelists could come back on and we could seek some kind of conversation between ourselves. So a couple of things that I feel like each of the panelists has kind of brought in that has resonance with others. is the need to move from an abstract individual as the subject of rights to either identity, but also communities. And I think that conversation was kind of resonant amongst all of you. The other was, of course, how, again, laws that are beside the laws that govern access to abortion also end up significantly affecting our access to rights and reproductive justice, whether these might be laws governing legal capacity, whether these are laws governing access to marriage and child sexuality, or whether these are laws that are around recognition of trans identities and so on. And then, and I think that in those ways there are, and of course there are other kinds of really important resonances between the panels, but I will leave it at those. But maybe I'm going to ask questions to each speaker, but I would really like it if other speakers also join into the conversation, and feel free to respond, to ask questions, because I think in the next 10 minutes, it's just a conversation between all of us. Maitri, I was wondering, because you covered so much kind of detail in your in your opening comments, I was wondering if you wanted to kind of speak more about, at last, what you made this kind of conversation towards solidarity, in which, and I think that's a real kind of departing from the subject of reproductive rights as understood as rights bearing on an individual citizen, to ideas of reproductive justice that are about communities and solidarities. And I was wondering if you have any examples, or if you could kind of elaborate more on that idea for now.
Sorry, can you hear me now?
Yes.
So yeah, thank you for that, and for pulling together these themes in such a sort of thoughtful way. I'm still thinking through what you just said and what you asked, but I think the question, so there's an assumption of individual autonomy that's at the center of certain conceptions of reproductive rights, just yesterday I was, now I'm going to talk about consumerism, but just yesterday, I was invited to give a talk at a rally on Saturday, and I don't have any good rally clothes, I admit. And so I was looking for a green shirt, that would sort of like express my commitments to abortion rights and sort of signal these solidarities with Latin American groups, with the Green Wave. And, everything I found, sadly, in my used clothing store was like, all centered on individual reproductive autonomy, right? The sort of my body, my choice argument, the even more problematic in my view, my uterus, my speech, which are sort of like the dominant language in this country, in the United States, of sort of making the case for reproductive rights. So I guess to kind of cycle back, that example came to mind just now when you were speaking, because of how different or how difficult it has been to sort of move beyond this centering of the individual, which, as Blas was also pointing out, right, also assumes a cis woman, a heteronormative subject, an able-bodied subject, and all of that. And even the very notion of autonomy, I think, that comes up in the Sister Song definition of reproductive justice also risks sort of bleeding into a set of claims about individual autonomy that are actually hugely problematic. So I think that, especially in this current moment, right, in this in the United States, with the leak of the Dobbs draft and sort of the waves that's made globally, I do really see this moment as kind of our chance as organizers in the US, but also abroad, to think very deeply about the need to break with that model of sort of my body, my choice, and think about the ways in which many people's bodies are deeply implicated in positive and negative ways with communities. Communities are not the answer, right? I mean, communities are also hierarchical and oppressive. We can talk about casteism in communities. So I'm very wary of offering a community as an alternative. But I do think that to understand reproductive injustice and oppression, we do need to sort of think about the role of communities, both in perpetuating those oppressions and in providing the spaces and the solidarities from which we can challenge them. So I think I'll sort of pause there, except I guess one last thing then also to add is that if we're going to think about the movement as moving beyond abortion, but also to make connections with movements that have not seen themselves as linked to reproduction at all, but that I think deeply are. So I'm thinking here about environmental justice movements, of land rights movements for Adivasi and indigenous communities, et cetera. I also think we need to be thinking about, forms of community belonging that offer alternatives to the kind of atomized, autonomous individual that's subject to state or criminal regulation. So I'll pause there.
Thank you for that. That was really a very elaborate, very comprehensive response, far more generous than my question. Nikita, I was wondering, and I'm going to make this kind of twofold, really a question about an anti-caste imagination in this twofold. One is that one of the histories around control, like the reproductive rights conversation in India, has been around population control and development. And I'm wondering, that seemingly seems like a non-carceral conversation, but we know that is not true. So I was wondering if you could perhaps also speak about development itself as kind of tied to that. And then, of course, also maybe expand. We understood really well from your presentation the relationship between criminality, sexuality, and reproductive autonomy. And but I was wondering, where would an anti-carceral imagination kind of take us? So where would we go with that imagination? So maybe those two questions, if you could perhaps answer.
Yeah. I mean, I think,
and also just for the translators, be slightly slow.
Sorry. So, I mean, what I was saying earlier is also, I think what I was alluding to is the fact that a sort of anti-carceral and an anti-caste imagination, and particularly like the sort of rights-based framing is not something that can be achieved within the context of a criminal justice system framework or a criminal legal framework, right? By which I mean to say is that it's a framework that is premised on the redressal of harms in a purely individualized sense, whereas the sort of prosecution or rather the persecution is at a community level, right? I think we've been talking a lot about how it's important for us to think about questions of community rights. But this is a system that acknowledges the communities insofar as you see, insofar as one is thinking about the question of controlling crime, right? So therefore it's, it's a sort of like a natural outcome that whether it's Dalit communities or Adivasi communities or Muslims or any other kind of marginalized communities are overrepresented within the system. But when you think about the question of justice within the system, the question of justice is therefore an individual idea, right? And I want to flesh that out a little bit because, I mean, we've been talking about how it's almost sort of become a default that reproductive justice is about the rights of cishet women to get abortion. And I think the outcome of any criminal legal framework or framing of rights would be that justice is always going to be premised on an individual, and the individual is always likely to be an individual who is, white cishet, a white cishet woman, or in the Indian context, an upper caste cishet woman, right? And I think it is, of course, in India, a gift of the savant feminist movement to all of us, that, we think that there is a sort of almost like a trickle-down theory of justice has been premised on criminal law, where we're told that, yes, it's important for us to invest in this. And if that individualized default is able to access their rights, it's gradually going to trickle down to the rest of us, at least some parts of it. I mean, we've seen the sort of pitfalls of the trickle-down theory as an economic theory, but for a long time, it's also been posited as a justice theory. So I think it's important that, that sort of framing around, criminal, like any sort of community rights framing, for that to happen, it's important that we're thinking thinking about the question of harm around outside of the realm of criminal law, which is what, like any kind of redressal of harm it's become synonymous in so many ways with criminal law alone, right, within the Indian context. So I think any kind of framework, an anti-caste and anti-casteral framing also of sexual and reproductive rights, and I don't like saying anti-caste and anti-casteral, because I think particularly in India, an anti-caste imagination within itself and within that sort of, like, the anti-caste project involves an anti-casteral project, because we've been talking about to talk about how the criminal justice system is rooted within Brahmanism. So any kind of anti-caste imagination is synonymous with an anti-casteral imagination. And I think, as Maithili was also saying, that it's important for us to then extend this anti-caste imagination to what justice might look like, not purely within the sexual and reproductive rights space, but what justice or redressal of harm would look like if we were to take it away from this individual harm versus community persecution kind of lens, to thinking about it as building communities around redressal of harm and building communities, because I'm also wary of presupposing the existence of communities and the romanticization of the idea of communities, but thinking about how communities can be built around the redressal of harm, and therefore centering questions of accountability around that. And I think that is that is sort of key to any kind of anti-caste vision of sexual and reproductive rights.
Thank you for that, Nikita. A lot there again. We seem to have lost Maria, so maybe I'll ask Blas' question first, and instead of me asking, maybe I'm going to ask a question from the audience. This has come in the Q&A. This is from Maximilian Rifkin. They're asking, I have a question for Blas. You mentioned Halsanger and her program of revisionary conceptual analysis. What do you think debates about the metaphysics of sex, example, essentialism of someone like Alice Byrne versus the contextualizing of someone like Sarah Richardson, have to offer to the conversation around reproductive justice, and vice versa? If you don't think this is relevant, please feel free to ignore. I will leave this to Blas to take up.
I'm sorry, I can't speak right now, but just if you want to follow, and I will be back in just 5 minutes. I promise.
Okay. Please take your time, Blas. And Maria, maybe we can take up 2 questions that seem to have also emerged from the audience. So one of them is about, to what degree can we look at the law as a site to realize reproductive justice? And I think this really ties up to the conversation you were having about the failure of the law. And the second, and even though this is to all panelists, maybe you can speak from your perspective. How can intersectionality be meaningful in practice? How can we advocate for SRHR for all without leaving some people behind? And I think this, and the thing that I wanted to ask you in particular was around, say, what are the best practices to address neurodiversity within the law itself, or in a context especially where disability itself has to struggle against its own medicalization, right? So one of the kind of great struggles around the disability movement has been precisely this struggle against medicalization. So legal capacity gets to be quantified precisely by medicalization. So how do we fight on both of those registers? So if you can feel free to choose to answer any or all of these questions.
Thank you. They are all way too interesting for me to get through all of them in the next couple of minutes. So I'm going to start with a couple of bits, and I'm going to try and do the like condensed 101 answer for all of them. I think with the law, it isn't to say that law can't be useful as a tool to achieve rights, to achieve social change, to guide it. I think part of our problem as a movement is that we've entirely pinned all of our hopes on that, even though it has repeatedly failed again and again and again. And often we buy into oppressive systems within the law, including on ideas of capacity, including on things like carcerality. And we're doomed to fail if we constantly pin all of our hopes on a system that has entirely failed, particularly more marginalized groups within our movement. So I think that's it. We can still use it as a tool, and it can pave the way. Like decriminalization, like can happen through legal mechanisms, and that can be really useful. But we have to right size it, because the law ends up playing an overburdensome role in our households. In our households, in our communities, in our hospitals. So we need to like really see how we unpick and dismantle that. In terms of intersectionality, that actually, I think, within our movements, I think that's actually about power structures within our movements. And like, again, I think people are far too willing to like have like a picture of like as many diverse faces as possible. I can remember working on reproductive campaigns where I was told, can you please find us someone in a wheelchair? You know, where we've that panic, where we want it to be seen. And then obviously the newspaper would cut the person in the wheelchair out of the final image that made it to print, because where we want it to be seen to be diverse. And even if grassroots movements start out as being inclusive, you know, in Ireland, we have a fairly trans-inclusive feminist movement, at least compared to our neighbours in the UK, or in England rather. Disabled voices became part of that movement. Migrant voices really carved out our own spaces within in the movement, migrant voices and disabled voices. But when it came to actual campaigns, it still sort of felt like anyone who didn't fit the mold was a bit of a guest in that movement, and centering anything other than that was seen as like politically risky. And I think we're still recovering from that in Ireland as a movement. But I think if we had approached it with that like grassroots, anti-hierarchical, maybe a little bit of an anarchy-driven movement, those hierarchies wouldn't have been created in quite the same way. And as for the medicalization, I'm conscious we might need to finish up, but I do think that like the pathologization and the medicalization of disabled bodies and minds is something that we see again and again. We see it more broadly in maternity care. We see it in gender and in terms of like what people of diverse genders are put through in order to access support that they need. I think we're going to be unpicking it for the rest of our lives, but I'm going to leave it at that, because I'm conscious that interpreters and stuff might need to finish, and other people might have a point.
So we've just been told that we have a good 25 minutes more, so no one has to feel rushed. And so Maria, if you want to come back with something, please feel free to. Blas, do you feel able to answer something right now? But only if you feel able, really.
Sorry about that. I have the flu, I have fever, so sometimes I can't just speak because I'm coughing. But I just wanted to offer just a quick answer. I believe that sex essentialism is, well, it's really contrary to the framework of reproductive justice. It shows a phase of the gender wars that is closing the very possibility of achieving reproductive justice. And this is even the case, and we can see it in activists, particularly feminist activists, who do not identify publicly as essentialists, but are still maybe unwillingly committed to the notion of sexual difference.
Thank you for that, Lars. We have a question to the whole panel, and I don't know if whoever feels comfortable answering that question. This is from Radha. They are asking, thanks for the great presentation discussion on RJ. I have one question. In the context of climate justice, there's a discourse of the rights of future generations. Do you think this theme also belongs with the frameworks of reproductive justice, and how? So anyone feels like taking up the question of like climate justice and its relationship to reproductive justice?
Sure, I can start us off. I think reproductive justice is a really capacious term, like I said. So I do think that the question of the rights of future generations can certainly be part of a reproductive justice frame. But I would also really caution about what we mean by the rights of future generations and how we're connecting that. Because I think, and I've argued this in the book and elsewhere, right, that the climate crisis has created a context for the reinvigoration of a discourse on population control in India, in other South Asian countries, and in much of the global South. And this is obviously the climate crisis is a real thing. And so I think the problem of that connection has been to suggest that the responsibility for the climate crisis should be borne by the poorest and most marginalized of people, including women, but not limited to them, who may become pregnant and therefore sort of reproduce the next generation, and that's seen as the driver of climate change, rather than what's actually the driver of climate change, which is the emission of greenhouse gases that comes largely from corporations and industries. And so consequently, I think that there's a setup here whereby, we can once again, as we have historically, sort of blame people for reproducing for actual social problems in the world. Now it's climate change. Before it was the idea of a population bomb or poverty, et cetera. So I guess that's the sort of first cautionary piece I want to look at. But if we are to sort of center the rights of, or maybe not center, but to think about the rights of future generations, then I do still think that reproductive justice has a space, right? And that's that last piece that I talked about in the definition, right? The right to raise our children in safe and sustainable environments, right? What would that entail in the here and now? And how would that benefit those of us who are currently living and generations that are to come? I think that's a really core question. And so if we are able to sort of center that question and not the sort of the blame sort of rhetoric and discourse that returns us to population control, then I think there is a space.
Does anybody else feel like they want to add to the question of climate justice and its relationship to reproductive justice?
I mean, sorry.
No, bolo, Nikita.
No, I was saying that, like, in any case, I mean, the climate justice question cannot be severed or from the question of, say, forest rights or the rights of Adivasi communities, tribal communities, and indigenous communities, right? So if one is thinking about the question of climate justice, it's important that we are centering it within the rights of these communities, because it is the rights of the reproductive rights of these communities that are crucial to thinking about the question of climate justice also, right? So I think any kind of population control sort of narrative that Maithili was talking about, that is, in any case, that is not a narrative that is either invested in the question of climate justice or the question of securing of reproductive rights. It's just a question. I mean, it is ultimately like the sort of eugenics model, which we've seen very often now, particularly being in India, being employed against Muslims, right? So we've seen that is, I mean, that is not a justice question. It's a question that's antithetical to the idea of justice in so many ways.
There's a question for Maria in the Q&A. Someone is asking, how can the global disability rights movement prioritize SRHR?
So this is something I spend a lot of time thinking about and more time possibly shouting about in my role as an activist. But I think it is the growth of feminist disability rights organizations that specifically center the voices of disabled women and gender minorities. And I'm proud to be part of one here in Ireland. I'm proud to be part of an organization, the Disability Rights Fund, that, you know, supports those movements kind of across the globe, and we're seeing it grow. You know, it was basically from the outset, disability rights tended to kind of focus more towards a very specific type of disability and or very specific types of disability. It tended to be more white men with physical disabilities, even though there was obviously iconic women and people with various other disabilities that were there. But even in terms of when you say disability, I often think people are really surprised that I'm not a man who uses a wheelchair, because that's often what people expect to get in terms of disability rights acts, in terms of disability rights. I think we're starting to recognize just the diversity within that movement globally, and we're starting to see more voices to the fore. Alongside this, I also think we possibly need to make sure that we're actually centering disabled voices. If you go to any state in the world, any international event, you will generally find really long conversations about education that are often led by the parents of disabled children. And that's important, right? Like educating, I'm a former disabled child who was educated. Like I'm really big into making sure that people like into those rights. But we focus so much of our energy on that when my reproductive life is going to be about 40, 45 years. Whether I choose to parent or not will define the rest of my existence in ways I can't probably understand unless I actually do it. But that element of disabled lives is so often ignored at certain louder interests that aren't necessarily coming from within our movement itself. So I do think it is about, you know, supporting disabled feminist voices, but also supporting building organizations where disabled feminists can talk about this stuff and advocate on it and grow, because I think what you'll find is if you put a whole bunch of disabled feminists together, we're going to talk about this stuff. Like we're going to talk about this stuff. We'll talk about little else. But actually just with the structure of movements and the siloing of movements and the focus of movements towards kind of the most privileged voices within it, we've lost that up until this point. So I'm hoping I become more and more optimistic the more time I see inclusive feminist disabled movements grow all over the world. So I think that is changing, but it's also possibly that most of the people I know are disabled feminists. So maybe it's not as prevalent as I think it is.
May I add something to what Maria has said, Vikram? So, I mean, I think it also ties back to what we were talking about earlier about the medicalization question, right? So the way that the law sees this is also to say that, you know, there are certain bodies that are normal and therefore need to be protected, and therefore I mean, so, you know, within the MTP Act also, it says that one of the reasons where abortion is allowed or medical termination of pregnancy is allowed if the fetus is quote unquote abnormal, right? So any kind of abnormality in the fetus will then give the person the right to seek an abortion. So I think it is this sort of framing of certain bodies as being normal and abnormal, and that sort of medical framing to say that, you know, there are certain fetuses that are normal and therefore deserve to live, and there are those that are quote unquote not normal and therefore don't deserve to see the light of day, right? And that medicalization and, you know, medicalization by the law across the realm of sexual and reproductive rights is in very different ways just reinforcing the standard of saying that ultimately a cis-able-bodied, preferably male person is one that is the normal standard, and anybody who's not adhering to that standard is abnormal. And I think, I mean, we see this in sexual violence cases also, particularly in India. Each time the court wants to get into the determination of whether there was sexual violence or not, you will summon the doctors and the forensic experts who will look at, you know, marks on the bodies of the person who's been sexually violated to then sort of ratify or attest to that kind of violence. And then, there is the ridiculous 2-finger test when you insert 2 fingers within the vagina of the person who's been, to determine whether there has been sexual violence or not. So it's ultimately the standard of, say, chastity, virginity, and the standard of being a normal, proper person in the eyes of law, and the way law and the sort of medicalized version that the law espouses, that I think we're trying to push forth. And I think which is why, the question of disability rights and challenging that framing is extremely crucial.
Can I just jump in with a further thought coming out of some of those comments? So it's interesting, right? Because the liberalization, so-called, of abortion law in India, makes a certain kind of disability exception, right? And says that, well, if the fetus is determined to have an abnormality or whatever, I can't remember the language that's used, then an abortion at a later stage of pregnancy is deemed legal. Flip side. And again, this is sort of like part of my dual existence is, writing about India and living and doing my other work in the United States. One of the, prior to the sort of straight up overturning of Roe that we just got with the Dobbs draft decision, is that another kind of wedge issue or sort of wedge law in the United States, including in the state of Ohio, which is where I live, has been to limit abortion specifically for fetuses who have a diagnosis or suspected diagnosis of Down syndrome. So this is actually currently law in Ohio and in a couple of other states. And so without going into too much detail, so basically the law says, you can have an abortion because that's legal under Roe, but you can't have an abortion if the reason for your having an abortion is because you have a fetus that's diagnosed with Down syndrome. This has been put forward by the antis, right? The sort of anti-abortion sort of right wing that puts forward this legislation as a disability rights measure. As to say, we are interested in protecting and valuing the lives of disabled fetuses, disabled unborn children. And therefore, we're putting this bill forward. It's been actually, to me, it has really kind of shown the weaknesses of a feminist reproductive rights or justice movement that has not worked in solidarity with disability rights movements, because this becomes this wedge issue that can be exploited, right? It's not, these laws, like the Down syndrome bill, is not coming from a disability rights perspective that values the lives of disabled people who are alive. It's just another step towards a kind of fetal personhood push, which is behind the agenda in the United States. But it has been incredibly difficult to contest because the movement in many cases has not built those solidarities and has not been able to sort of take on this question of advocating for abortion from an anti-ableist perspective, right? And so I think this is just Nikita's comment sort of reminded me of how this works in the US as well.
Maria, do you feel like you want to add something to what Mike said?
Yeah, and there's probably some of the stuff we might have, I had possibly thought about touching on today, but just haven't necessarily. And it's a really difficult space, I think, for a lot of disabled feminists to live in. There have been examples where disabled feminists have really spoken out against the kind of laws which prohibit abortion based on disability. And that's then, that same text has been used to expand abortion based on disability, even though that's not what the disabled feminists themselves were arguing for. But the nuance, and so the nuance that kind of happens within those spaces is so often ignored and overridden, and it's sort of a rock in a hard place. And if we don't have that solidarity there, if we haven't built that, if we haven't also, if the broader feminist movement also hasn't maybe done the work around ableism and some of their own internalized ableism, it's really, really difficult. I genuinely think a lot of the reason we see these, I think particularly here in Ireland, because the fetal abnormality or the fetal anomaly ground is how the law is in the UK, there's like this absolute thirst that that's what we have to have here, which is so weird. We don't want anything else to be like English people. We spend like, that's a particular tension on this island, not in the entire island, mind you, but at the very least in the Republic. But oh no, that's what they have. That's obviously the gold standard in terms of what we want in abortion access, even though it centers abortion around the fetus, which is a terrible idea, both in terms of like, both from an advocating and a construction of law, right? Abortion should always be about the pregnant person. Like, we don't make it about the fetus. Like, that's a weird thing for us to do, but just because the English have done it, I guess we all need to do it. But beyond that, it totally removes the person themselves, how they feel about their pregnancy, what they think, with it out of that discussion, which is just a bad idea for how we're supposed to talk about this stuff and how we're supposed to provide for this stuff and how we're supposed to support women in crisis pregnancies. And like, I think we've talked a little bit about medicalization. There is issues with the fact that these conversations and prenatal diagnosis conversations often happen in the place that have the lowest expectation for what disabled people's lives look like, often happen kind of drowned in that like very ableist ideas of what our lives look like. But we can't even have those conversations because we have to use these really weird constructs. And at the point where we challenge that, not even challenge it, but like maybe raise questions about it, it often feels like we're then viewed with suspicion. So I love being in these spaces where we can really have these conversations with like a degree of like openness and come to the table. But yeah, I will stop there because I have way too many feelings on this, and we'll talk forever. But yeah, they're kind of the immediate points that come to mind after that discussion.
No, thank you for that, Maria. And thank you and thank you to each of you for that really rich conversation that everyone partook in. There is, and maybe this might be the last question before we wrap up. This one's coming from Dr. Aqsa Sheikh, and they're asking this of both Maithili and Nikita, and maybe see whoever feels like answering this. Taking into consideration how sometimes framing of laws, this is in the chat box, so I don't know if you can still see it. Taking into consideration how sometimes framing of laws leads to more restrictive frameworks, like the Trans Persons Act in 2019, the ART, Artificial Reproductive Technology Act, the Surrogacy Act, etc., as compared to leaving gray areas. Is it risky to demand laws for regulation of SRHR as compared to leaving it unregulated? So the question's asking that if we've seen that actually when we've demanded specific expansion of rights, what the state has done is actually ended up making laws that curtail those rights. So for example, the extension of citizenship to trans people has meant the curtailment of their laws. Dr. Sheikh is asking, is it better to actually leave some areas as gray, leaving certain sections of abortion as unregulated, and so on and so forth? It's a very provocative question. And so anyone who feels like answering, I think even Maria might be able to answer this. So anyone who feels like answering can take this up.
I mean, I think statist regulation is disciplining, and I think any kind of regulation, whether it's within the realm of criminal law, which we have seen fail spectacularly in multiple ways for so long. But any kind of statist regulation, even in other ways, we've seen this in India, for instance, with the Domestic Violence Act, which sort of tried to veer away from this criminal legal framing of abuse to say, well, let's think about civil remedies, let's think about how you can center the harm cost to the person. And I think you've seen, with that framing also, you've seen ultimately a sort of disciplining of the person, the woman, suffering violence, to say, well, go back to the institution of family. That's where you belong. That's where your rightful place is. So I think any kind of statist regulation is a regulation that's ultimately going to require people who are trying to push back against it or trying to assert their rights. Any kind of assertion of rights also is going to be within that existing framework, in the Indian context, of course, of Brahminical patriarchy that we're operating in, which is what the law is embedded in. So I think and some legal, some sort of engagements with the law, movements see as victories, but those victories are also in so many cases, just old wine in a new bottle. So I think the question of regulation, and I think which is where Dr. Sheikh's question is extremely important, is that it's important that the question of rights and the question of regulation are almost always going to be at odds with one another. So I think we have to think and conceptualize the question of rights beyond regulation, whether unregulated or not. I think that framing has to be pushed beyond the question of regulations. Yeah.
I guess I'll just speak very briefly. One, sort of building from that, one thing that I've been thinking about from the panel, from the previous panel and from this one, right, has been the importance of decriminalization, obviously, which is distinct from these forms of legal regulation potentially. So I just wanted to sort of uplift that again as sort of a key part of the process, but not the end of the process, or the importance of decriminalization, and moving a lot of this completely. I'd agree with Nikita, outside of the purview of criminal law, which in the Indian cases and in the US case, right, is deeply rooted in colonialism, slavery in the US, et cetera. So I think that's important. I think the second thing, I mean, to me, like one of the fundamental problems or failures that we face is less a question of law, and here's a moment where I'm grateful not to be a lawyer, but is less a failure of law than a complete and utter failure of systems of health, right? And of rights to access healthcare, and reproductive healthcare is one component of that. And we know in the Indian case that maternal and child health, for instance, has consistently been underfunded and devalued in favor of population control measures that themselves have been incredibly harmful. And that's just one example. The Indian health services, that's Indian referring to Native peoples in the United States, similarly was a drastically underfunded system that turned to modes of oppressive sterilization in the context of a complete lack of resources for maternal and child health. So I guess I just want to sort of point to that as another horizon that we need to be thinking about and looking at when we talk about SRHR.
Maria, any thoughts?
Yeah, not anything particularly that hasn't sort of already been said, but what I am thinking about is like the recent Irish examples of where we've tried to like really regulate human reproduction, and we've done like what have supposedly been emancipatory measures to really further, I suppose, particularly LGBT people's rights and also people dealing with infertility in terms of having families. And these things that are always put forward as like these gains for these communities have invariably created subsections who are further removed from their rights. And I'm thinking particularly of like trans mothers being trans mothers. I'm thinking of like LGBTQ parents kind of across the spectrum in this, where we've gone for this form of regulation as this idea of a win, and what we've ultimately done is caused more people, not necessarily more people, but further removed people from their rights, right? It's become harder to explain to this point, have not served us well.
So on that note, I really would take the opportunity to thank all panelists, especially Blas, who joined us through with immense suffering, and we wish Blas the best of health and that they recover really soon. And thanks to Maria, Maitri, and Nikita for joining us and for this really rich conversation, and to all the organizers and all the labor, if that's not some really contested word today, all the labor that went into this conversation. Thank you. And maybe now we'll turn to Dr. Aqsa Sheikh to give us the vote of thanks. So have a good evening from the Reproductive Justice panel side.
Thank you. Thanks so much, VQ, and also our other moderator, Andrea, and all our panelists, for such an engaging and interactive discussion that we had this morning, evening, depending upon whatever time zone you are in. Now, before we close for the evening, we want to take this opportunity to really acknowledge the efforts and, as VQ mentioned, labor of all the individuals and organizations who have been instrumental in conceptualizing and executing this symposium. Today, as we witness significant developments across the world, that could have critical and long-lasting impact on the global landscapes of SRHR, it's also very pertinent to hold spaces for these discussions and to bring together, different key perspectives, especially from the marginalized groups, for adopting this framework of reproductive justice. We would really want to acknowledge the work of those who have come before us and provided us with the vocabulary of reproductive justice, especially Black feminist activists, critical scholars, anti-caste, Dalit, Bahujan, and Adivasi activists, as well as queer and transgender scholars and folks, for developing this conversation around reproductive justice. They have been extremely instrumental in guiding our efforts as a collective towards creating this space for the conversation. First and foremost, our thanks to our wonderful and lovely panelists and moderators. We would want to thank Alicia, Clara, Agnieszka, Phyllis, Maithili, Maria, Blas, and Nikita for joining us in spite of the limitations of the time zones and very odd timings across the panelists. We would really want to acknowledge the efforts of our moderators, Andrea and VQ, especially who came, and kind of salvaged the situation for us at the 11th hour, and who have facilitated this beautiful conversation over the course of the last more than 3 hours in such an engaging and interactive manner, and creating this democratic space where everyone has a voice. We have been extremely fortunate in having the opportunity to learn from each one of us, including our participants across the globe. We would want to acknowledge the tremendous efforts of all our interpreters for this series, including the ISL interpreters, Preeti, Gargi, and Aniket, who's doing interpretation right now, for making it possible, for making this conversation accessible to everyone. I can't help but thank the IT team at Jindal Global Law School, who have been extremely supportive and instrumental in ensuring that this webinar is able to reach out the audiences without any interruptions, as you have witnessed yourself. In this time and age of virtual interaction, we have all learned to adapt to this new way of engaging. And none of these conversations would have been possible without the efforts of our IT team. That's Vishnuji, Rahulji, and the team at the Jindal Global Law School. We must also take a moment to thank the Vice Chancellor of Jindal Global University, Dr. C. Rajkumar, for his unwavering support for making this conference possible. We'd also like to thank our organizers and partners, the Law and Marginalization Clinic at CGLS, Shruti Disability Rights Center, Transcare India at Sangat, Rising Flame, Asian Pacific Resource and Research Center for Women, Center for Reproductive Rights, Trans Men Collective, and Common Health India for facilitating this key discussion and conversation on decriminalization of abortion and reproductive justice. Last but not the least, we are extremely grateful to all the participants for spending the Wednesday morning, afternoon, evening, depending upon whatever time zone you are in with us for this more than 3-hour-long conversation. Thanks a lot from our entire team, and we hope to see you for part 2 of this symposium in August 2022. Thank you, everyone.
Hi, can we stop the live stream, please?
Yeah, we'll be offline in another 10 seconds.